SJC-12101, Fred Chitwood v. Vertex Pharmaceuticals, Inc.
Mr. Purcell, good morning.
Good morning. May it please the court, Stephen Purcell on behalf of the appellant Fred Chitwood. With me today is my co-counsel Mitchell Maturin. This appeal raises essentially two interrelated questions. One, do shareholders of Massachusetts companies have a meaningful right to inspect corporate books and records under Section 16.02 of the Massachusetts Business Corporations Act? And two, is the process by which a shareholder makes a litigation demand on a board of directors going to be a meaningful process, or is it going to be a peremptory and secretive exercise?
Counsel, can I just ask you before you start, do you agree that it's a clearly erroneous standard with regard to the facts found by the trial judge?
No, I don't, Your Honor.
Okay, what standard do you think it should
The standard of review is de novo, and the reason for that is it is clear from the trial court's articulation of the standard and the trial court's ruling as a whole that the trial court misformulated the standard that applied. The standard that actually applied and that my client was required to meet is he needed to present some evidence to support a credible basis for the court to infer possible wrongdoing. The standard the trial court, in fact, applied required my client wrongly to present affirmative evidence of actual wrongdoing.
But the letter was just a letter, wasn't it? I mean, Senator Grassley's letter, was that evidence of wrongdoing?
Your Honor, I think it's important to emphasize the operative words in the standard. Some evidence to support a credible basis
Okay.
to infer possible wrongdoing. So with respect to your question about Senator Grassley's letter, there was a lot more to the situation than the letter. The letter was something that came out initially in response to the events in question, specifically a 3-week period.
A newspaper report, basically. He didn't have any information. He was looking for information, right?
I disagree, Your Honor. I think there was a lot of information. I think there was a lot of evidence. And perhaps the issue we're discussing is the form of the evidence or the type of the evidence. And there is a case in Delaware that explicitly says you can make a credible showing of potential wrongdoing through documents, logic, testimony, or otherwise. And one of the fundamental problems here with the trial court's approach is the judge said that Mr. Chitwood failed to provide specific information. Wasn't entirely clear what was meant by that, but specific information, essentially rebutting the conclusions that were reached by the special committee in rejecting the litigation demand. That is not the standard. And effectively, what has happened as a result of the trial court's ruling is that Section 1602 is a meaningless and ineffective right. And second, because of the circumstances of this particular case, the process by which a board of directors reviews a litigation demand is not going to be a meaningful process. And in Massachusetts, a state where a shareholder must make a litigation demand prior to commencing any derivative litigation, I think it is especially important that the shareholder right to inspect books and records be meaningful. And here,
It's meaningful if you have something that it warrants looking into, right? The standard is, it's not meaningful if you can't go on a fishing expedition.
correct, you need to have, there are a couple of principles that I think are clear from the law. One, importantly, is that this is a minimal burden, and that is by design. And in part, the reason for that is the right of inspection is a basic and fundamental right of shareholders to, among other things, monitor the activities of their agents to whom shareholders have entrusted their property. And the commentary to the statute is actually very clear on that. This is a right that cannot be eliminated by making changes to the corporate bylaws or corporate certificate. It is a fundamental right, and the right is for the shareholder independently to monitor the activities of the corporation.
Well, here's my concern. The actual right to inspect is really quite limited in scope. It speaks of excerpts from minutes reflecting action taken. So basically, at a director's meeting or at a meeting of a committee which is acting in place of the board of directors, but the drafter's comment makes it clear the intention is to permit inspection of votes or action taken on relevant matters, not of reports or discussion. So you're allowed to know what actions were taken at the board meeting and to get the minutes which discuss what the actions were, and you're allowed to get the accounting records of the corporation, but if they're audited, if you have an audited financial statement, then you're limited to that, and you can get the record of shareholders, which I assume is the list of shareholders. That's what the statute provides, and I understand that that's pretty basic and that there should be only a minimal threshold, but you asked for, essentially, what you asked for goes well beyond that. You were looking for the committee's work papers, the minutes of its meeting, the notes and memorandum prepared in connection with the investigation, earlier drafts. You were essentially saying, give me everything with regard to the internal investigation so I can examine whether or not the board's report was appropriately done. That seems to be a very different scope from what the statute provides.
Your Honor, I agree that the scope of the right of inspection is narrow and it is limited. And in fact, that comes into play with respect to the argument, ultimately an argument that the trial court agreed with, that Section 7.43 and Section 7.4, the shareholder derivative statute, essentially foreclose a shareholder from invoking his right to inspect books and records in a situation where a nominally independent board has rejected a litigation demand. And the point, Your Honor, is the right of inspection is not tantamount to a discovery right, but it does speak to excerpts of minutes and also actions taken by a committee acting on behalf of the board. I don't think there's any question that the special committee, which was formed by the board for the express purpose of conducting an investigation and developing recommendations to the board on what should be done with respect to the litigation demand, that those activities were done on behalf of the board. The fact that the nominally independent members of the board subsequently decided to accept the special committee's findings and recommendations and reject the demand in no way eliminates the right of inspection.
Okay, but even if you're right, then let's just, you get excerpts of actions taken. The excerpts from minutes reflecting the action taken. You wouldn't, I mean, how do you get work papers, notes, memoranda, earlier drafts? How does that fall within the scope of the statute?
I'll say two things, Your Honor. I think, number one, it is important to emphasize that the scope of the permitted inspection is a separate issue from whether an inspection of some sort should be permitted.
Well, I understand that. But I guess I guess where I'm coming from is to say, yes, it's a very minimal standard because it's a very minimal scope of what you can get.
Right. And I think to the extent that some of the requests were formulated in a manner that would exceed what the statute permits, that's something that the trial judge can deal with and circumscribe the scope of the requests. And here, of course, what happened is after litigating the case for years, my client got nothing whatsoever. And I would like to return to the question of evidence because it relates to the special committee, because this was a key piece of evidence that I think fundamentally changes the nature of this case. And it was something that the trial court ignored entirely. So if we step back and look at how this situation arose, there was some highly suspicious insider trading that occurred at the company during a 3-week period, close to $40 million worth of stock. And the company had made some very positive announcements that created an artificial increase in the price of the company's stock. And that enabled insiders to make these profits by selling shares, a lot of shares, during this period. The company then discloses that the initial statement that caused the increase in the company's stock price was not true. The market reacts, the stock goes down. A United States senator publicly declares that these events were troubling and says that there should be an investigation. Now, that came after a company spokesperson initially came out and said, there's no problem. All of these trades were appropriate. They were either done in accordance with pre-existing 10b5-1 plans or otherwise in compliance with the company's internal policies.
Can I just stop you there and to get some clarity on timing? When did you request the documents? Was it after the investigation was done or before the investigation was done by the company?
We made a litigation demand on the board of directors to investigate the activities that occurred.
So that was made before you requested the documents?
Correct.
So you went to inspect the documents only after the investigation was done?
Correct. And in part, Your Honor,
Would it have been any different if you made the demand after the Kratzley, to inspect on the basis of basically the Kratzley letter before an investigation had taken place, do you think?
well, here's my
Because the
response to that.
investigation results basically figured into Justice Sanders' reasoning, don't you think?
The investigation result,
He had the investigation behind her as an historical fact that the company had done this. If the company hadn't yet investigated, you think there would have been any difference in the analysis?
I submit that there shouldn't have been. And this actually goes to a question that Chief Justice Gantz asked me, which is the scope of the inspection and the types of materials that you can acquire pursuant to the statute. At the outset, a determination was made, and these are not mutually exclusive rights, the right to make a litigation demand versus the right to seek books and records. They're supposed to coexist. They're two separate things. But at the outset, it seemed apparent that given this particular situation, there was unlikely to be any board-level documents concerning the situation. And given that Massachusetts is, in fact, a demand-required state, and even states that don't require shareholders to make a litigation demand forcefully encourage the making of a demand rather than launching a lawsuit, the decision was made to make the demand. Now,
Can I just ask you, if you don't think it should have made a difference as to whether it was before or after the internal investigation, what's the purpose of asking for an investigation? What could they have done that would have satisfied you that there wasn't anything going on that was untoward?
well, Your Honor, I think that the fact of the matter is here that there are two paths to accessing books and records in this context. There's the proper purpose of investigating possible wrongdoing at the company. But I think independent of that, there's a proper purpose in evaluating whether the board of directors' refusal of the demand was made in good faith and based on a reasonable investigation. And there is a lot of authority in Delaware and outside of Delaware for that very proposition. And here, given the emphasis that had been placed on the special committee's investigation and its findings, which were essentially described in Mr. Cronin's letter to me, they reviewed documents, they interviewed people, they looked at it carefully, and they didn't see any wrongdoing, and they concluded that a derivative action would not be in the best interest of the company. However, it is a documented fact that in the middle of the special committee's investigation of the litigation demand, the outside, nominally independent directors signed their names to the company's annual report, which represented that the allegations purportedly then being investigated were without merit and that the company would defend itself vigorously. We have cited several cases in our brief that make it clear that in that situation, you cannot repose any confidence in the investigation and the findings that the special committee made because they had prejudged the allegations. And this is very clear in the testimony. It was admitted by Vertex's witness, who is one of the members of the special committee. And I think that fact contributes significantly to the totality of the evidence that was submitted and allowed a court, viewing it objectively, to infer a credible basis of potential wrongdoing. And I see that my time is up, so if there are no further questions, I'll thank the court for your time and consideration.
Thank you. Mr. Cronin, good morning.
Good morning, and if it may please the court, Todd Cronin for Vertex Pharmaceuticals. With me today is my colleague, Bill Brady. There were two issues I wanted to address, as well as responding to anything from this court. And the first is to start with the opening question that was asked by the court with respect to the standard of review, and then to address the issues under the Massachusetts statute. And in that regard, it's very significant, I believe, that while there are certain circumstances, while this court and other courts will look to courts of other jurisdiction, including Delaware, for guidance, that does not apply where there is a comprehensive Massachusetts statutory scheme, particularly where that statutory scheme here in 1602 sets forth different standards than are in Delaware. The Delaware rules for what constitutes the scope of documents you can get and what constitutes a proper purpose are different than those set forth in the statute.
We know that by looking at the face of the statute or only by looking at the commentary concerning the statute?
You can look at that from the face of the statute. And you do that when you look at 1602 because 1602A says there are certain documents you get as of right as a shareholder, and 1602B says others are subject to conditions and limitations. The ones you get, and there's no such distinction in Section 220 of the Delaware law. And the ones you get of right are stockholder lists. Every stockholder has a right with no showing whatsoever to get a stockholder list to communicate with other stockholders. However, stockholders do not get a right to other corporate documents under 1602B. Those are just enumerated documents, as the Chief Justice pointed out. There is no such enumeration in Delaware law.
Does Delaware have a comparable statute, or is it only a matter of common law?
It's Section 220 of the Delaware Corporations Act. It is a comparable statute in the sense that it is a statute addressing the circumstances and scope under which you can get corporate records.
That's derived from the same model as our statute?
I do not believe it is. In fact, our statute came out in much later after the Model Business Act. Delaware statute has been there a long time, and as you can see from the drafter's note, the Massachusetts statute is consciously different from Delaware law on these specific points.
So do the Delaware cases that reference is being made to construe the Delaware statute?
Yes, Your Honor, and that goes right to the heart of the questions the court has been asking, which boil down to be, in Massachusetts, can you get inspection of the special committee work product? The answer, we believe, in the text of the statute is clearly no, and that's the entire driving purpose of their request. The answer in Delaware is different. Yes, you can, and he's got cases to that effect, but the Massachusetts legislature drew the line differently with respect to the types of documents to review and the showing you need to make to review even that subset.
Did Judge Sanders, in referencing a decision of Judge Fabricant, or then Judge Fabricant, but isn't behind that Delaware law?
There is behind there Delaware case law, and the case law concerns, very broadly, both statutes have a proper purpose test, okay? But that's all that Delaware says on it. Massachusetts takes you through what that proper purpose means and how it has to be supported by reasonable particularity and how it has to be connected back, the documents seek to the purpose. Those are all laid out in Section 1602C. No such similar provisions are in Delaware law. But what both courts, and indeed all 50 states would have to say, is what type of evidentiary threshold is there for a proper purpose? And Judge Fabricant adopted and endorsed the Delaware test, which is used elsewhere, as a very minimal showing of some objective evidence of wrongdoing sufficient to warrant a further investigation. And that is what the case was tried on.
So let me get back to if after the initial period where there were the misinformation that was out there that caught Senator Grassley's attention, I'm sorry, and at that point a stockholder requested the documents that were within the scope of the statute. Wouldn't that be enough of a showing at that point to get the documents that this statute says that the stockholder can have, because that would seem to be like a proper purpose?
I believe, Your Honor, the answer to that question in that hypothetical is yes. Of course, we know that's not what this
That's not what
plaintiff
happened
did.
here, but I mean, I'm just trying to...
But I agree with you. Yes, it would, but they would get excerpts of the minutes showing actions by the board in connection with the conduct that is allegedly wrongful. They didn't want that. What they wanted is to wait, trigger the special committee process, and get the special committee work papers in order to try to find evidence that they could use in a separate action. And that's expressly prohibited by the Massachusetts statute.
And so why is that not the answer here? Is that we have apparently a narrower scope of records which may be made available than Delaware, and it appears that we should be interpreting the good faith and proper purpose in light of the fact that you're not asking for, you're getting stuff which is pretty basic.
We agree completely on that, Your Honor, and that was presented to Judge Sanders below as one of two grounds. First ground was the evidence that they have no actual evidence of any to create even a minimal inference of wrongdoing here, and that was.
But why would they need that here?
Well,
I mean, if they were truly asking for what the records are provided by statute, all you're going to get is excerpts of minutes reflecting actions taken. Why should a shareholder in general not know what actions were taken by its board?
well, first again, we know that that's not what they're requesting here, Your Honor.
I gather.
Okay?
That's why I'm worried that we're focusing on Judge Sanders, who's applying a test with the view that what they're asking for is to essentially be getting the records that would allow them to second-guess the director's, the independent director's finding, and it's all being done purportedly pursuant to statute, but the statute doesn't provide for those records within its scope, and it seems that her test actually would arguably be too tough for records that would be within its scope.
I want to go to that latter issue in a moment, Your Honor, but it's important, I believe, in the context of this case, that there have always been two arguments as to why the inspection demand is improper. One is that it seeks documents beyond the scope of the statute, okay? And that was briefed and it was presented to the court. They didn't get to that element, okay? But this court can, and we hope does, because it's an important roadmap for Massachusetts corporations, stockholders, and directors. And clearly, these special committee materials are not subject to inspection for all the reasons the court itself has observed. With respect to the evidentiary showing, okay, there is a requirement of some minimal or some threshold evidentiary showing. Simply asserting you have a proper purpose is not enough. All sides agree on that, and that's clear from both the statute and the drafter's notes. Otherwise, you would really be able to have a fishing expedition for corporate documents by every shareholder for any broadly stated purpose. So something more than that is required, okay? And in the context of this case, which went through a trial in which the judge then applied that minimal threshold showing of some evidence, there's credible evidence to show wrongdoing, they failed to make that minimal showing. And that takes us back to Justice Budd's initial question, which is that part of the decision by Judge Sanders is subject to a clearly erroneous standard.
If her standard is correct.
Yes.
Yes. Yes.
So there's an error of law if she's not correct. If we decide that the standard she's imposing is not the correct standard, then that still meets the abuse of discretion test.
I accept that, Your Honor. And if we can, although I will say the alternative grounds which the Chief Justice has raised is clearly here on the facts of this case. Turning to that issue, Your Honor, which is an articulation of a standard of what type of showing must be made to meet a proper purpose. It is, I think, clear and accepted by both sides and by courts across the country that there has to be some factual showing made in order to warrant that. And the factual showing that was used by the Superior Court, which carries over from what the Delaware courts have developed, is some evidence which objectively viewed provides a credible basis to believe there's wrongdoing. And thus you look at the total set of facts you have to see if that warrants further investigation.
That's the issue. They say it's some credible evidence of the possibility of wrongdoing, not of wrongdoing itself. Which one do you say is the right standard?
The possibility of wrongdoing, Your Honor, is lower standard, but that is fine, okay? Because on the facts of this case, they couldn't make that showing, and that's specifically what Judge Sanders found, that they presented no credible evidence to support an inference of wrongdoing through the whole evidentiary process of a trial. That's her finding of fact.
But the judge essentially asked them to say, show me why the directors, why the letter, I forget whose name it is. No, not Senator Grassley. The letter that was issued saying we've received your demand and we're not going to pursue further investigations. She basically said, show me why that's not right.
Respectfully, that's not what she asked. She said, okay, the senator sent a letter. The company then thoroughly investigated that through an independent directors and a vote of the independent members of the board and gave you a 10-page single-spaced letter. Show me in light of that body of evidence any inference of some possible wrongdoing. And they were unable to do so. Okay? That is the factual context there, Your Honor. That this did not happen on day one of the case. And before there was a special committee process, this happened not only after they received they went through the process, received the 10-page letter, but a trial at which the lead director took the stand and was subject to cross-examination on the process, on the findings, and they weren't able to show any evidence of either a lack of independence or a lack of diligence, good faith, and thoroughness in the investigation. Not a shred of evidence, according to the court. That's her specific finding in the order. Okay?
So is that, if the inspection demand had been done before that investigation, would the standard be different?
The standard would not be different, but the evidentiary basis that you would look would be different in the sense that all you would have would be the senator's letter, okay? And the question is, does that create some, along with other circumstantial evidence, does that create some reasonable inference of possible wrongdoing?
You always have to have wrongdoing to have, to get any, the minutes, excerpts of the minutes? You got it?
Yes, Your Honor, otherwise it would be part of 16.02A, in which you have an automatic right to it, and you don't. You have a right to it only upon showing of proper purpose, which, to avoid the fishing expedition, includes some minimal factual showing. That is why the statute is structured that you have certain documents as of right, such as a stockholder list, and others a conditional right to, within a smaller subset, excerpts of the minutes, upon a showing of a proper purpose. Otherwise, every stockholder could ask for every Board of Directors excerpt minutes, and that's just not the line that the Massachusetts legislature drew.
But why should we necessarily find that the only proper purpose is the possibility of wrongdoing?
You don't need to, Your Honor, but that's the allegation they made. That's their stated proper purpose, and everything does have to come in a factual context. There could be other proper purposes they might state, you know, to communicate with shareholders about some issue, to look into executive compensation. But those aren't our issues here. So when one does need to be grounded into fact, because the question is proper purpose for what? And here it was to investigate wrongdoing, to build a case for my derivative action. And that's beyond the, they didn't have any factual support at all for that, and it's beyond the scope of the statute as well. And I would say, Your Honor,
Well,
go on.
so, I mean, if what was being sought were just documents that would otherwise be within the scope of the statute, you're saying even as to those, the proper purpose has to be evaluated in light of the investigation, the evidentiary showing that was already there?
In light of the total quantum of facts that are known at the time, yes. Okay? Sometimes there won't be, I mean, again, that goes right back to your initial question. If they had sent out a request pre-investigation for excerpts of board minutes only, and were able to say, here is the evidence which, objectively viewed, supports an inference of possible wrongdoing warranting further investigation, then they would get those excerpts of the minutes. That is not the path they followed. Okay? And so the proper purpose test will be applied based on the facts, but it requires some threshold showing.
Even to get the same type of documents that are clearly within the scope of what the statute provides?
Yes, Your Honor, I'm assuming that to be a proper purpose, they have to go within the scope of the statute in the first instance. Otherwise, the statutory scheme wouldn't work, which is one of the fundamental flaws in their request.
Am I correct that the statutory scheme was meant to be simple?
Yes, Your Honor.
It wasn't meant to impose, to have $500,000 of legal fees imposed to see whether they can get the records sought here.
And Your Honor, I agree with that, and so does my client, okay? And the statute also in the drafter's notes talks about ways in which that can be avoided. And for every justice who's been on the Superior Court is very familiar with that. Very early in the case, present the documents for request in-camera review. That's specifically what the drafter's notes say, where there is a dispute about the scope of the request and the reasonableness of it. Submit it for an in-camera review. That was never done here. Ask for an expedited trial date or a summary proceeding date. That was never done here. Okay? We took the first the case was delayed in part because it got transferred from Middlesex over to the BLS. But once that was there, we took the first available trial date that Judge Sanders assigned to us. No continuations of a trial date. We took that to trial that day and brought in our independent director from out of state to testify. So there was no delay or foot dragging on the part of the defendant here at all. And there was no effort, respectfully, by the plaintiff to find any expedited way to get to the heart of these issues. And an in-camera review is a very easy, straightforward, and recommended process in these cases that was not followed.
I'm sorry to be so obtuse, but I'm reading the notes of the drafters who say proper purpose. The phrases "in good faith" and "proper purpose" are traditional and well-understood language in this context, cites a case. And then goes on to say, use of the same term ensures that the very substantial case law defining it will continue to be applicable, which suggests to me no one is suggesting you're going to have a trial over this every time.
Oh, we agree, Your Honor. We don't think there should need to be a trial over this every time. Again, and they can provide, if we read further up on there under 1602B, where it says the statutory statement of good faith and proper purpose should create greater certainty as what records may legitimately sought by a shareholder and what standards a court should apply to these requests. This should encourage compliance with legitimate requests for inspection. The issue on the facts of this case is that's not the documents they were seeking. There wasn't a legitimate request properly tailored to the statute.
Well, then isn't that the answer? Stop, right there. Why do you have to try whether it?
Because they disputed that, and we had a motion for summary judgment which was not heard. Instead, the court said, we're just going to put it down for a one-day trial. We presented a motion for summary judgment on that precise issue, and it was not heard.
Okay, thank you.
Thank you.